not to be construed or relied upon as being legal advice for an individual legal situation, or implored for making a legal decision. You will not use any of this information for making a legal decision or performing a legal procedure, and is not a substitute for legal advice and or guidance by a licensed attorney. This private show and or documents are for academic informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing this show or using the documents therein, you understand with agreement that, with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state, and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of herein referenced, and has no interest in any use referenced therein, and is not a party to this or any action arising from, and is only acting in an authorized capacity as liaisons to communications between the parties. By reading and or using this information, you acknowledge and agree that you are not a client of Christian Walters. These documents and our show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. Thank you for your understanding.
I'd like to welcome everyone to this Tuesday, February 22nd, 2011 edition of Money, Banking, and Trust by Moving Titles and Commerce. I'm your host, Christian Walters. Welcome to NTT as New Trust Technology. Let's see, I'm going into the Gibson's book, Treatise on Suits and Chancery, and I'm going to page, let's see, section 21. Section 21. Okay, section 22, excuse me. All right, it's on page 42 of the PDF, section 22, classification of matters of equitable jurisdiction. First, I want to give it a couple definitions on Black's Law. Black's Law, 8th edition. Definition of characteristic, or character. Okay, characterization, Black's 8th. Characterization under the classification, qualification, and interpretation of laws that applies to a case. So classification, qualification, and interpretation of whatever it is. And now nature. Nature, Black's 8th. Nature in the Black's Law 8. Number 1, the fundamental quality and that distinguishes from one thing from another, the essence of something. And number 3, a disposition or personality of someone or something. And number 4, something pure or true as distinguished from something artificial or contrived. Number 4 again, something pure or true as distinguished from something artificial or contrived. Keep that in mind when we read this. Section 22, Gibson's. Classifications of matters of equitable jurisdiction. The importance formally attached to the proper classification of the subjects of equity and jurisdiction no longer exist in this state. Keep in mind we're talking about North Carolina as originally being part of Tennessee, and now we're talking about the state of Tennessee. And it is now immaterial whether the matter in controversy is within the equitable or statutory jurisdiction of the court. And if within the equitable, it is unimportant whether the jurisdiction be exclusive or concurrent. As a result, all the abstruse learnings in the books on the lines of demarcation between the different grounds of jurisdictions has ceased to be of much practical value. The legal niceties, the complex technicalities, and the dialectic discriminations on the subject of jurisdiction with which great jurists of England and America wrestled in the last 5 centuries no longer perplex either the student or the practitioner in this state. For convenience of consideration, the jurisdiction of our chancery courts is now constituted, may be divided into 1, the equitable or inherent, and 2, the statutory. So we have the equitable or the inherent, number 1, and we have 2, the statutory. So here we have the two streams of jurisdictions in one court procedure, and it was the same back then in 1907 as it is today. And it says, number one, the equitable or the inherent. To include all those matters, whether purely equitable in their nature, pay attention to that definition, nature, or having characteristics, pay attention to that definition, characteristics both equitable and legal, jurisdiction over which is derived exclusively or chiefly by their inherent powers as courts of equity. And two, the statutory, to include all those matters whether equitable in their characteristic or purely legal in their nature, jurisdiction over which is derived exclusively or chiefly from our statutes. So in the two separate jurisdictions, the equitable, the inherent, and the statutory, in the equitable inherent, it's whether purely equitable in their nature or having characteristics both equitable and legal, versus under the statutory, whether equitable in their characteristic now or purely legal in their nature. So how does this all tie in? Well, keep in mind that a party can only transfer what right that he has at the time of the transfer. And keep in mind that we also are dealing with two kinds of title, most generally, which would be the legal, and specifically, which would be the, or especially, which would be the beneficial title. Now, let's suppose that ABC Bank is foreclosing on you, and they claim a beneficial interest against the legal title. My first question is, can they have a beneficial interest? No, because there was no beneficial interest in the legal title at all to be transferred to the bank. And they know that. They know that because they're confusing it and calling it a beneficial interest, but its beneficial interest is only in its characteristic. And the characteristic is the same as under the statutory definition. Characteristic, it's equitable in their characteristic or purely legal in their nature. So it's a legal nature title, legal in nature title, but its characteristic is beneficial, which does not make it beneficial. It's a counterfeit look-alike. It's not the true nature as being beneficial. It only has the characteristics of. It's not the real thing. So they know that. And they come out with these beneficial interests against the legal title, which is beneficial in its characteristic, but not in its nature. Where the equitable in its nature is purely equitable, and it can also have characteristics both equitable and legal, because the equity part, the beneficial one, is superior to the at-law legal title. So does the bank really have a claim? Well, the maximum of equal equities, the one with the legal title will win. So if my equity is equal to your equity and you have legal title, you will win over my equal equity. But they don't have an equity that's beneficial in equity anyway. But I do. And that would be a superior claim to the legal, although it's beneficial in its character. It's not beneficial in its nature, and therefore it's nothing more than a legal title. And it can't overcome the beneficial interest, the real nature, beneficial nature. So just another way how they confuse you on the terminology of splitting hairs a little more finer. And again, the legal title can't transfer a beneficial interest if it didn't have a beneficial interest at the beginning, at the time of the transfer. And would the real beneficiary please stand up? And that real beneficiary has to be you. But if you don't make your beneficial claim in a court of equity, you're going to waive it at law, and the general deposit, the debtor-creditor relationship, the legal title at law will win out. And again, the Maxey Center case points that out also. Read that again, Maxey Center, Hutchinson versus Maxey Center case. And they were talking about a replevin bond and making claims equitable at law, which couldn't be done. You had to bring your equitable claims in equity first and have them established. Then if you don't, you waive it. So pay particular attention and study those words, characteristic and nature, as applicable to, number one, equitable or inherent jurisdiction, and two, the statutory jurisdiction. And then apply that to your mortgage foreclosure case or your car, or anything else in life. Keep in mind about the two titles, beneficial title and equitable title. Remember, the beneficial title can't be seen in equity, or in at law, in the legal side. And that's Section 57 in Gibson. So let's open it up for Q&A, and press *6 followed by 1 for getting in the queue line and asking a question.
Q&A session started.
Press *6 followed by 1 to raise your hand to ask a question. *6 followed by 1. Anybody? Question? *6, anyone? Followed by 1. Question? Okay, we're in Q&A mode, so come up with some questions, anybody. Anybody? *6 followed by 1. Question? Hi, Carl. You're unmuted.
Hi, Christian. Yeah, this whole idea of how to distinguish between the nature and the character of the titles that we're using is, and I confess that I've only read it once, so it's still very confusing to me, and I can see how it would be used to cloud the issues, especially in mortgages, because you're using the same terms in different ways. So how would we clarify what we're talking about? How would we talk about the fact, let's say, in a bill, or would you even put that in an indenture to say that we're talking about the fact that there is no beneficial title on the legal title, let's say in a mortgage case, and that our equitable characteristic would trump the or be superior to the equitable nature and who even has that? Does that go to the Queen? And I don't mean to get sidetracked on that, but where is the equitable nature if it's not there originally?
Yeah, the Queen never granted the equitable nature to anyone in the United States or America. All she granted.
And I'm sorry that she's ill, but I don't think that it's going to pass to us with her passing either.
No, probably not. It'll go to the inheritor of the office. Yeah.
So how do we talk about the equitable character of our title and show that it is somehow superior to the equitable, the legal character that, let's say, the supposed lender has?
Okay, the lender is trying to slap a disguise on the legal title by calling it a beneficial interest in character, which that's kind of like a misnomer statement because it can't be beneficial interest only if it was beneficial in its nature. So it has the characteristics of it, but really it's not. But that's just a disguise that would give them a superior claim against the legal title holder so that they could take it, so that the Lord could be in by his cheat, the Lord being the bank, so to speak.
So really the title is bifurcated initially when the Queen never executed the equitable nature title, and so the only title that exists really that's being tossed back and forth is this legal title, which has a beneficial character that if it was brought to court would appear to be equal to our beneficial title claim, but because they also have the legal title, theirs would be considered superior.
Right, right.
So how would we, using this language, recreate our superior claim or reiterate?
We have to bring a claim against their beneficial character and make it distinguish that that beneficial characteristic is not equitable or beneficial in its nature. I object, Your Honor, to their beneficial characteristic claim that they have. Because it's not beneficial in its nature, it's beneficial in its character, and that's two different things. One's a counterfeit, and the other one's the real.
But that would be done in an at-law motion?
Well, yeah, that could be.
Okay.
Because they claim it's a beneficial title in its character. That way they can bring it on the at-law side so they can bring a claim against the legal title.
So that would be a defense to their motion.
Yes. Mm-hmm.
But once you get into the equity side or the jurisdiction, then you wouldn't be necessarily making that claim, or would you still need to make that distinction somewhere so that you would be taking the superior claim even though they both appear to be equitable titles? Once you're in the equity jurisdiction, the bank, I would say, couldn't show themselves as beneficiary.
Right.
So really that distinction is more valuable in the at-law side than it would be in the equity side.
No, I think it works both ways, even in equity, because
that's the part
now they don't
missing.
have an equitable claim that's superior to mine. There's no equal equities.
Well, it would appear to be equal. What makes it superior?
Well, priority for one thing.
Because my claim came in first.
Right.
In equity. Mm-hmm. And they can't claim in equity.
Right.
Okay.
They're purely corporations, and corporations are at law, period. They can't even have a beneficial claim in equity.
Well, I appreciate that, because that was really confusing to me.
It would only be beneficial if it had a beneficial nature. And they can't, as corporations, have a beneficial nature. They can't have that title. So it's really fascinating how they split hairs and slap on disguises to hide the facts that they don't have what they think they have. And if we only knew that, and we could use it to our own advantage, because you have the superior title. You're the one who issued the grant.
Right, so what we're doing is the opposite of divide and conquer. We're using merge and conquer.
Yep.
So it's anti-Machiavellian. All right, well, I don't call in very often, but I appreciate you taking the time to chat with me.
Okay, thanks.
Thanks.
*6 followed by 1. Anybody? Questions? *6 followed by 1. Anybody have a question? Get in the queue line, raise your hand. State your name, where you're from. Questions, anybody? Now's the time to ask them. Doyle, you're unmuted.
Hello, Christian.
Hi, Don.
Hey, I want to go back and touch the concept of the nature and character of the claim.
Mm-hmm.
Now, in Doyle's case with the bankruptcy, the Chapter 7 trustee is going to go back and revisit the foreclosure, and he's going to go all the way back to June or whenever the transfers were done.
Okay.
In order for them to come in and do the bankruptcy or the foreclosure. Now, could we not bring in this concept of the characters and natures of the claims with the lawyer and have them to go at that whole process with that in mind?
Yeah, you could bring that up in an adverse claim and have the trustee possibly reverse that, and because it wasn't equitable in its nature.
Well, the trustee of the bankruptcy or the seventh trustee is implying that that's the direction they're going to go with that, and they're going to go back and revert the whole process.
Yeah, I think this is what they're scared of. I think they're scared of the nature and characteristic being exposed for what it is.
So that would definitely be something that we need to sit down with the lawyer and go over.
Yeah, yep. I think that's one of the key things they're trying to keep hidden, and I think they see that you're knocking on that door, and if you get that figured out, the emperor has no clothes. The game is up.
Well, the trustee was definitely interested when he heard this, because when Doyle initiated the bankruptcy, the first attorney who was supposed to file the paperwork, what have you, he told Doyle that the house was gone and that was the end of story. Well, when the trustee hears about this, he says, that's crazy. So they're now going to go after that whole issue, bring it into the bankruptcy.
Yeah, I think
they're saying there's enough assets in that asset alone to take care of the bankruptcy and still have money left over, or funds, or what you want to call it.
Right.
So they're definitely going to go and...
Like all these banks, they foreclose on you. They'll sell a house at the auction sale for $100. Somebody that's actually working for the bank bids on it, buys it, but it's a separate corporation, say, and a separate entity, and although they're working in collusion together, and then they turn around and come back and counter-sue you for a deficiency judgment on the balance. So if you had a $100,000 house and it was sold at auction for $100, and you still had the mortgage on there, say $100,000, you'd owe $999,900 yet on the mortgage, and they'd have the house and a deficiency judgment for that amount.
Yep.
And they leave you penniless, groveling in the streets, and then they come up with all this legal-ass crap at you because they know you don't have a dime to spend on an attorney.
Right.
And they can get away with this stuff because they know the legal process, and you don't.
Yep. Well, they have a whole team of lawyers working on it, and you're there by yourself trying to figure things out.
Right. It's a travesty.
Yep.
And then to top it all off, they had no claims whatsoever because their characteristic of their beneficial interest was a bag of hot air.
Yet the court allows them to do what they're doing.
Yeah, that's Section 57, is it? The waiver and Gibson?
Yeah.
You know, the waiver is the biggest thing that stomps us in the foot and hangs us because we waive everything which are our rights. 71 was the section, excuse me. We waive all our rights because we don't know what to say at the time we need to say it. And we're the ones that are supposed to be sovereigns, and we're the ones that are supposed to be doing government. But if we knew government and being sovereign, we'd know how to run government. We would know what to say when time need to be said.
We witnessed it when the people are represented by lawyers. The lawyers will step right there and let you waive your rights and not say a word.
Yeah, because they're legal in nature and they can't represent your rights.
Yep.
They don't have a license at law, which is an attorney's license, and that doesn't cover equity, where the rights of the real man really are. The only one who can stand up for his rights is the real man himself. Can't hire anybody else to do it for you.
Yep.
Now we're back to doing government, and that's what we're on this show's for here, to wake people up and get them back in the driver's seat.
Yep. Well, you know, that was interesting because that was the comment that the lawyer made about Doyle's case, and the standing trustee, 13th trustee, he had come into the court, and he was in the driver's seat, and she was in the passenger seat and back, and she wasn't happy.
I love it. I love it.
Yeah, it was kind of funny.
Let's hope we can take it to completion and get it adjudicated still in the driver's seat too.
Yeah. Well, we go to the trial on Thursday for the adversarial claim. Now, I think we mentioned it to you earlier that they set up the court date but never noticed anybody. So we went online and found it. So we'll be showing up.
An intentional oversight, but when I got to that hearing, I sure would be complaining for them to produce a record of them giving you notice, because I'm going to come in and claim they never did. And that could be pushed into some sanctions on the attorneys, you know, because they're operating inequitably.
Well, who was ultimately responsible for that? The standing trustee, or
you are for making the claim. If you don't, you waive it.
Noticing.
Yeah. If you don't complain that they didn't give you notice, then you waive the right to come in and object and do something about it.
Well, that'll be part of the opening statement that you didn't have proper notice.
I'm sure the judge will ask, well, how did you know to appear here? So
Found it on the computer.
Oh, well, he'll probably say, well, you had notice then. But the trouble is, it wasn't sent by the attorney. It's supposed to be his responsibility to notify me, not me find out when the hearing's coming up.
Yep. Well, now, if he's pro se, is that still applying?
The attorney's pro se? You're pro se.
Yeah.
Sure, it would.
Well, on all of the other notices of the hearing, a notice came from the court. They mailed them out.
Is this the adversarial hearing, or is this in the bankruptcy case?
Oh, yeah, the adversarial hearing as well.
Okay, I think the attorneys are supposed to give the documentation to the trustee, and the trustee mails it out. If they didn't give the documentation to the trustee, then how's he going to mail them out?
Well, I guess that's a good question. Why are they having the trial if they're not going to notice people who are involved?
That's a violation of due process. That'd make every verdict out of that void on its face. which might be what they want. You know, I don't know.
Well, the attorney also said that based on what Dole had said about trust, over the weekend he went and did his homework, and I think he went and read the Restatements of Laws on Trust, volume number 3, and came back and told Dole that he had them by the balls. That's the reason they're reacting the way they are.
That's what he said? The attorney said that?
The attorney? Uh-huh.
After he did his homework, huh?
Yeah, because Dole told him that in order to express a trust, all you need are the elements, that we talked about, to express trust, and a method of delivery, and the law must recognize it as a trust. He came back, and the lawyer came back and told Dole that, he had done his homework, and what Dole said was true. And based on that, he felt that he had them by the balls. Dole had them by the balls, so to speak.
Fantastic.
We were kind of shocked that the lawyer or the attorney would actually admit that, but he did.
Wow. Yeah. What else did he express after that? What did he say? Any suggestions from him, or what you might be doing, or?
Well, they weren't quite sure how they were going to handle the adversarial claim. They charged him an X amount for the bankruptcy, but they said that they might have to charge even more to do the adversarial claim. And I think Dole pointed out to them that they were not going to be needed to do the adversarial claim because it's in equity, or should be. We'll see. Mm-hmm. And all he's going to do is request a decree on the validity of the trust.
Did the attorneys make any comments on that at all?
Beg your pardon? Did
the attorneys make any comment on that at all?
Nothing other than he what he said about the fact he had a trust as he said he did, and it was legitimate.
So he really wasn't divulging any trade secrets or anything that he knew that might help you out then?
No, not at that point. I don't know. Should he involve the attorney in the adversarial claim?
She the trustee?
No, he's not the trustee. He's just the attorney for bankruptcy.
You mean your attorney? You mean get him involved in the adversarial claim?
Yeah.
I don't think so. I'd try to keep him out if I could. I would maybe use him for advice. Maybe if he could charge a fee or something for advice, if he's got something good to help you out with.
Right.
But I think if you get that attorney involved in this adversarial claim, I'm afraid he's gonna
mess it up.
Yeah.
Yeah, that's kind of what we were thinking. But I think they were thinking that they were going to walk in and take over, and I think we made it clear to them that no, you're to take care of the paperwork. And the Chapter 7 trustee is, well, as we know, this is not a normal bankrupt case, so the Chapter 7 trustee is telling Dole things, and then the attorneys come in and say, well, you haven't done this, or you've not done that. You're not going to get a hearing, or you're not going to get a creditors meeting or whatever. And he said, or Dole would tell the attorneys, well, the Chapter 7 trustee said be there for the hearing on such and such day. Well, they called the trustee, and sure enough, they're going to be there the next day. So apparently being handled completely different from what they're accustomed to.
Well, that's completely different, huh?
Wonder why.
So apparently they're dropping out some steps that they normally would under equity then.
They're dropping out some of the stuff that they would normally require of a normal bankrupt person who's coming in and doing the normal things. Like, for example, Dole never paid a fee and says that if you don't pay your fee, you get kicked out of bankruptcy. Mm-hmm. Well, he never paid a fee, yet he's still there. Well, he hadn't paid with FRN. All his payments were done with merged titles.
That kind of rings to where equity looks through the form, process, and procedure into the substance.
Yeah.
So they're bypassing the form, process, and procedure of the bankruptcy court and going directly into the substance of the equity.
Yeah. Well, now, that being said, and we know that everything's paid through merged titles, why are they working out a deal where if he pays them $25,000, everything will be taken care of? Can he not just go ahead and merge title on that debt and give it to them?
Yeah, you could do that, yeah. See, they're still trying to argue about the legal titles and see who gets possession of that.
Yeah. Well, that's what he's planning on doing is whenever they present him with the bill, just
Like you almost can't hold the possessory title or the legal title yourselves because you're going to make yourself trustee of that. You almost got to give it to the trustee, who is the United States, and then get an agreement with the United States that you get to live in the house or the property, say 99 years.
Yeah.
And if they were going to charge to make it all legal, so to speak, you could take the asset as payment out of the estate and make the payments on the lease.
That would be the tax.
Mm-hmm. You could come out with a stipulated agreement to that effect.
Yep.
That might be worth discussing that with the attorneys to see whether they could strike a stipulated agreement with them on that part. That would be involving the legal title. Have them send you a bill for 99 years worth of taxes and pay it out of the estate.
Through the trustee.
Mm-hmm. Draw up a lease. I want to run that by, think about that a little bit, and see what maybe some of the other details might be.
Now, if this worked out correctly, there will be a trustee appointed, and that will be his duty, is to take care of all this stuff, right?
Yeah. Who's got the possessory titles right now?
I'm assuming that they would be in the bankruptcy, because the trustee told Dole that all the claims that supposedly were against him are in the bankruptcy, and anybody who had a claim would have to make a claim against Chapter 7 bankruptcy, and would have to prove claims. And he was saying that 99% of the people who had claims like that, when it comes time to prove their claim, they don't show up.
They don't show up. Well, they would be defaulted then. So he doesn't think that the tax people would show up then?
He didn't say who would show up. He just said that in most cases they don't show up to make claims.
Does their claim stand, or does they get defaulted because they don't show up?
I'm assuming it's defaulted if they don't show up. And that would include any like credit cards or any of those kind of things.
Interesting case.
That's what they keep saying.
We only knew a little bit more.
We figure the attorneys are going to be educated a little bit in equity in this case.
Yeah, they probably don't have a clue what equity is.
They don't. And what equity they think they know is all statutory.
Right, yeah. Well, anything else?
No, that's all I have to question you about.
So Thursday is the hearing?
Beg your pardon?
Thursday is the hearing?
Yeah, Thursday at 1:30 in the afternoon.
And that's the adversarial claim for the decree from the validity of the trust.
Exactly. So we'll be getting all of our group together and meeting at the courthouse Thursday for their education.
I can't wait till Thursday to see what the outcome.
Yeah, it's going to be interesting. Is it possible that the judge might try to protect Sandy trustee and rule so that she would be protected?
Unless there was some way of protecting her, I don't see where he would.
Well, now, say that he does come in and say, yes, there is a trust here. Could the grantor not come back and ask the trustee to be dismissed, the trustee appointed, to relieve her of the obligation? Or would it be too late to do that?
Okay, now, what again? You're going to relieve?
Yeah, to protect her, not cause her to be a casualty. Come back and ask the court to appoint a trustee so that she could be dismissed. Or is it too late for that to occur?
I don't think I'd rock the boat that way. I think I would let it stand the way it is. She's supposed to have the performance and the duty, and she might be the one that has to be the scapegoat.
Yeah. Well, she's an attorney after all. She should know this stuff.
I would think if they tried to repudiate or something, then I would say that the court should appoint a constructive trustee over it and force them to do the duty, because now the trustee won't return the property or do the duty.
Well, she did try to return the property, but it was after the disclaimer period had long passed.
Yeah, well, you didn't ask for the property back, so
no.
It was supposed to be used for the destruction of the extinguishment of the debt.
Yep. Well, it kind of appears that people that are involved are really concerned about their position. Because all along they poo-pooed this stuff, and now all of a sudden they've gone back and read the book.
Found out there's a 900-pound gorilla there after all, huh?
Uh-huh. Well, they found out it's not monopoly money after all. Not that funny stuff, anyway. That was one of the comments that was used in one of the motions by that lawyer for the ADF&A. That Dole was paying tax monopoly.
No, I'm afraid it's the other way around. Your debt is a monopoly debt. because it's drawn against an equitable asset held in trust, and you generate debt and bond from the bonds and things that you've got against it, and then say the CAFR funds, and then you take a fee for that. And all your fees and all your money that you created is all debt money, which has no value.
Yeah. So basically, what he was saying was about himself.
Right. Right. The only true money is the true asset that you guys have.
Yep.
Not the other way around. There's where you come in with the nature and character argument. Claim is, in its characteristic, beneficial, but not in its nature is it beneficial.
Would we need to use that argument in the...
I think you use this argument based on anything, because really that's what it boils down to. They're trying to hide the nature of it, that they don't have the nature of the equitable, by giving it a disguise, calling it a characteristic of beneficial.
But so they're really calling things so first, right? They're calling a foul here at so first and getting by with it.
Correct, yes. Everybody sees the emperor with clothes on. No, finally, there's no clothes on the emperor.
Yeah. We made that be about the clothes of the emperor.
Yeah, this nature and character is, I think, a very major bingo here on... And yet it's so insignificantly small in respect, in a way, but yet it's so major in its impact.
Right.
Just a definition of between two words, nature versus characteristic. And we've been using these terms all along, really not understanding what we were talking about, really, up till now.
Well, haven't you said they kind of hide some of the most important things right out in the open?
Yeah, and right there it was in a 1907 book. It was probably maybe even before that, too.
Yeah.
And here for the last 100-plus years, nothing's really changed.
Kind of put on a shelf and not talked about.
Yeah, in fact, you could go back to the 1500s or the Dark Ages when trust came into existence, or 1200s there. You still have feudal times today. Same thing.
Same concept, just a different name.
Horse of a different color, but still a horse. You think the color made it different. No, it didn't. It's still a horse. Yep. Its nature did not, its characteristic did. In its nature, it's still a horse. We got a pink horse in characteristic or a green horse in characteristic, but the characteristic is not the real thing, the nature. And then they're in a court of consciousness now on the equity side, and now the consciousness of the court comes into play, looking through the form, substance, and procedure, all the quackery, and it must look to the substance. And now it's not at law as usual. It takes equity to overcome it, and it probably will.
Yep. No.
If we do it, it probably will. It'll have to. It'll have to. Except nobody's done this before. So we're rediscovering the equity courts and learning how to use the merged court procedures to invoke the equity side of the courts under a different law venue, different jurisdiction, different law form. I talk to a lot of people. They think that the equity courts are going to be just operating the same way as the at-law courts, and they don't. And they have this fear stigma of getting beat up in the at-law side, and they think they go into the equity side, they're going to get the same results. No. You fellas have proved that the courts, even in a little bit of shoving into equity, as we've been doing in your case there, that the courts act totally different from the at-law side.
Yep. And even though it looks like we've been beaten up, we're still there and haven't been thrown out or kicked out or sanctioned or anything. Now, what we just recently learned about the courts running concurrently is contrary completely to what the judge said in his verdict. He talked about his ruling that the equitable court and the at-law court had been merged. Now, those were the words he used, that they had been merged and there was no distinction between them. Now, here we're reading in the literature that that's not the case. Does he not know this, or is he thinking incorrectly? What's going on?
He may be using it incorrectly, and maybe he knows, maybe he doesn't know. But I just posted in the NTT group today, before the show, a book that I found out of New York, and I forget the year of it. I think it was like early 1900s. But in there it said that the court procedures have been merged into one, and it's reiterated again, just like it did in the Maxey Center case in Florida. But this was a New York Supreme Court case stating that the procedures had been merged, but still in existence there were two separate jurisdictions. Exactly what the Florida Supreme Court said. So this Supreme Court out of New York verifying that in this, in fact, I think it was Bouvier's book. I have to go look again. I don't have it in front of me. Right, just posted it again, so it's check the chat site out again. It's like, I think it was on page 6 at the bottom paragraph, starting there. So I think the judge is using it. You know, in fact, we've even caught ourselves speaking the same way, saying that the courts have been merged. No, they haven't been merged. It's the procedures that have been merged, not the courts. There's still two separate courts in the court system, equity and at law. But the procedures have been merged to get into either. So yeah, there's been a merger in the courts, but it's not the courts itself, it's the procedures. Now, they may not be distinguishing that, and maybe they know that, but they're trying to mislead people. Now, whether that's intentional, I don't know.
Well, I would think that if you took the word that he spoke and face value, then he lied on the bench because he said that courts had been merged. He didn't say the procedures had been merged. He said the courts had been merged. Mm-hmm. And that now there was one court.
Well, knowing what we know now, I would object and say, no, Your Honor, it's the procedures that have been merged. They're still two separate jurisdictions, two venues. Yeah. And I'll bet you'll find that in every one of the 50 states, because we can reconfirm that in New York now for the same thing that was stated in Florida in 1988, I believe, in the Maxey Center case, even though that was an earlier decision in New York. But you're probably going to find that in every one of the 50 states, yeah, except for the ones that have chancery courts set up that haven't been abolished. I think New Jersey has a separate chancery court. I think, was it Mississippi or one of the southern states right in there has a separate chancery court, and I forget who else. But those that abolished the chancery courts, merging one into one procedure, but still two separate courts.
Separate courts under one roof.
Yeah, two different law forms.
Yep.
Well, anything else?
No, that's it for me. I'll get someone else. Yeah.
All right, have you got anybody else on? Okay, Darren, you're unmuted.
Hey, Christian, how are you?
All right.
Can you hear me?
Yeah, I can hear you fine.
Can you hear me?
Yes, go ahead.
Hello?
We can hear you.
Hello?
Hello, you can hear you.
Okay. So I was waiting for a call back. Okay, question, and this was something that I discussed prior to with a former TA, was in regards to an ongoing case where you create your UCCs, your indenture, you send them to the trustee, now they have notice, now they have a time frame to perform their duty and to, as per the special instructions. In the existing case that, of course, is filed in most of our counties, do we put a notice on the at-law side to any avail? Do we put a notice in there of some type? Or do we have to wait until we file our suit in equity?
No, I put it in like the county on the UCC, put the notices in there. You know, that's manifesting your intent. That's why we do the notices.
Okay, that's something because what it is, it's basically now in your pleading format, you're basically having the same format. And you're really using, you could use 3 notices to reflect the 3 UCCs that are filed of your intent and purpose. Now, do you think it would probably be wise, knowing the confusion that we're creating, is to have also a cover letter instructing the clerk of court? Are we instructing the clerk to file this on the equity side of the court, or is it still on the at-law side of the court?
Well, going by the older books, they had an equity docket all separate now. I don't know whether that still exists, or they're using one. I don't know. We're just
Okay, so basically we could, in other words, we could kind of like do a hit and miss and see what kind of reaction we get.
right.
I could, I'm pertaining to one particular case where I've sent the indenture to the trustee, but I've held off on the county
Yeah.
because I wanted to get some clarity on it and basically say, please submit this into the equity docket.
Yeah. What I'm thinking is that the equity docket has not been done away with. It's just been probably merged into the judge's chambers. And it's no longer held with the at-law clerk.
Okay. But it still goes to the clerk of court, per se, but we have to give instructions of where we want them to file it.
Mm-hmm. Yeah, I would think so.
Okay, very, very, very good, very good. That was my main question. Okay, so I'll know how to follow up on that.
Yeah, because I think everything that's private is held up by the judge, and everything that's public is held by the clerk. Clerk's
Okay.
the at-law side, the judge is the equity side.
Right. I'm sorry. Say that again, please.
The clerk is the at-law side, and the judge is the equity side. But he probably wears two hats.
So we should send it directly to the judge?
Well, I don't know. You might want to send it to the clerk because the clerk is the one who's supposed to be, probably he's going to wonder what to do with this, and he's probably going to run to the judge and what do you want me to do with this? No, he'll probably say, well, I'll take care of that.
Well, you see, I have one case myself, and I mean it's just so blatant, and they did procure fraud throughout the entire process, right down from suppressing evidence to everything. And then when I imposed the constitutional challenge, the chief judge stepped in and says, no, you can't file anything. This is over. This is done. Which he was recused when he was a circuit court judge back in 2005, and he stepped back into the case, which I still don't know under what authority he could do that, unless he's doing it administratively, but I'd still like to kind of challenge him on by what authority did you have to do that once you were recused from a case, because the way I understand the recusal rules and the codes is once you're gone, you're gone.
Right.
And so it'll be interesting, but okay, that's what I'll do. So I'll give it special instructions. I'll pop that in the mail tomorrow. So we'll kind of see how it goes there. And
so did you have an equity hearing for the validity of the trust for a decree?
No, all I've done at this point, I've used the notary to send the indenture. And then I'm going to wait for the time to lapse or to see what kind of answer I get. And I'm sure they're going to look at it and go, what the heck is this thing? Which is going to be interesting. But once that's done and I know I haven't been a breach, then that gives me my claim to bring in the suit in equity at that time.
Yeah, because it looks like you don't have it set on the equity side, and they're still running the at-law side railroad. So once you get the trust in place, come in for the dismissal and transfer.
Exactly. And I'll move it into the federal court, too, myself.
Well, I mean, transfer from at-law jurisdiction to equity jurisdiction in the same court.
Well, the thing is, I'm in a different venue at this time. I'm in a different locale at this time, so it would be a change of venue anyway, and I might as well move it into the federal court. Because actually the state that I'm in now, they can't hear it.
Okay. All right.
Yeah, because I'm outside of Florida now, and that was a Florida case. And the thing is really I can invoke pendent jurisdiction, which pendent jurisdiction allows the federal courts to hear a state issue.
So you're going to use the federal to bridge the two?
Yeah.
Well, then you could get it into equity right off the bat then.
Exactly. Bring it right in there, and because the thing is, they're not going to be able to claim like anything like the Rooker-Feld doctrine, because that's an outlaw doctrine.
Well, I think that's what
they normally do. They kick it. They try to bring it back into the state court.
Yeah. It's like Don said when he told the attorney when he went and did his homework and he came back and said, well, you got him by the balls.
Oh, it's got to be so interesting. You would love to be a fly on the wall once that paperwork is submitted into that court, and they're going, have you ever seen anything like this before in your life? I mean, if you break it down, if you look at the geographics of the United States, knowing since 1933 there's been about 100 cases in equity, what's the chances that that particular court has even seen one case since that time?
Right.
So you've got to be a fly on the wall, and because they're going to be sitting there going, educate me a little bit on this. You created it, so that's why we got to be sure we know what we're talking about once we get in there.
Well, that's what that attorney found out when he did his homework. Changed the story right like that on the snap of fingers.
Yep. I think it's going to be interesting. It's going to be very interesting. But even myself, I prefer the federal court over the state courts because it seems like they don't play many games there.
They run
would
a tighter
have
ship.
a better understanding.
They run a tighter ship if you can operate in there.
Yeah, right. I think they pay a lot closer attention to the rules than what the state court does.
You have to be a little better skilled than in state court.
Okay, yeah, but like I said, I've done the indenture, and I'm just waiting for the time period in there just to basically lapse. So this way, once I got them in breach, that gives me my cause of action right there. Now I have a reason to bring in an issue in controversy to the court, so saying, here, you decide this. I have an issue because the trustee has not been performing his duties as per the instructions. Here's what I see. Here's the relief that I see.
Mm-hmm.
So let's see what happens. Okay, so I'll file those into the circuit court tomorrow. Great. All right. Thanks a lot, Christian. That's my only question.
Okay.
Bye-bye.
Thanks, Darren. Star 6 followed by 1, anyone? Star 6 to raise your hand. Got an empty board again, so star 6 followed by 1, anyone? Questions?
Christian, am I coming through?
Yes, go ahead. Who's this?
All right. George in California.
Hi, George.
Yeah. First time I ask you a question, so be gentle on me, please. Anyway.
I'm not on anybody. I just...
Does it matter if there's an elected judge or a pro tem?
I don't think it's not going to make any difference who's the judge. It's the consciousness of the court and equity that's the important thing.
Okay. In California, there's in the Constitution, Section 6, Article 6, Section 21, that if you don't stipulate to a pro tem judge, they're required to give you an elected one. I was thinking they would know the law better than some attorney or commissioner that's been appointed for low-level stuff. What do you think?
Well, under the enforcement of the trust bypasses the Constitution and goes directly to the Declaration of Independence.
Right.
Unalienable rights and these truths are self-evident. Can't be transferred rights.
I understand. I'm just questioning their competence. Wouldn't an elected judge necessarily be more competent since you would think they'd be at the game longer?
Yeah, you may be right there. Instead of somebody that just came in or,
Right. Okay, next question. When you send a notice to someone, what's the difference in effect between signing it and not signing it?
Well, if I can prove that I sent it to them, and even though they didn't sign it, that's notice. Right.
I'm talking about a notice that you would send to somebody. Would you necessarily need to sign it?
Well, let's say I did a 3811 green card to somebody, and they did one of those little tricky things and didn't sign it. The fact that I sent it.
Yeah, I'm not talking about proof of service. I'm talking about a notice. The notice itself. Does the notice itself have to be signed at all times?
Oh, on your part, and you're sending it to somebody else?
Right.
I would sign it, yes.
Because there are instances where I understand it's better not to sign it. I mean, IRS sends you notices.
Yeah.
They're not signed.
Right. Sometimes it's not necessary to have a signature on there, but I would sign. I'm not afraid of signing.
Okay. You, of course, sign especially, right?
Yeah. Mm-hmm. Restricted by grantor or by beneficiary.
Right. Now, for a bill in equity, do you file a notice of that bill on the at-law side?
No, because I think the procedures are one and the same, and once it gets filed in, it's going up that channel. That is notice.
Okay. I don't know where I got that from. But, I mean, you're working on both sides, okay? I mean, to get relief, you have to work on both sides, right?
Correct, yeah. Well, we're taking control of the at-law side and moving it into equity.
So that's why I'm wondering why you wouldn't have to give a notice for everything that you put in on the equity side.
Well, I think everything that you do file is a notice, because the rules have been merged on both sides, though. And if you're filing through the rules, then that's notice to both sides. Because there's only one procedure now. That's what's been merged.
Okay. All right. Well, in that case,
kind of like what we're talking about with Darren there. The clerk is taking care of the at-law records, but probably maybe the judge has got the equity side docket records.
Right. That was another question. But to conclude this one, I don't understand if you put something on the equity side that it wouldn't be mistakenly brought into the public, because, you know, the clerks may not understand that.
Well, there's
you see danger.
There's those two individual realms that are like, you know, they're simultaneously existing at the same time, but you can't tell the difference one from the other, and it'll morph from one side to the other side without you even knowing it.
Exactly, and that's what I'm trying to address here. If you're putting something in the equity side, you don't want it to go public, so I would think you'd send it privately to the judge and then put a notice in on the public side. You see what I'm saying?
I'd be careful of the wording that I put in the motions and pleadings and things to make sure I didn't put any statutory at-law stuff in there, to keep it solely on the equitable side. And then I'll probably put in a motion in there to, you know, to seal the record. That would keep it from being exposed to the public once it's all finalized.
Okay, as part of the pleadings, then, okay.
Yeah, or possibly maybe even a protective order, and we're back and forth vacillating on that one.
All right. So how do you get a copy of the equity docket if it's in a judge's lap?
Good question. I don't know. Ask him.
Ask his secretary, huh?
He probably can't release it because it's private.
I mean, since it's between the private parties, couldn't he release it privately?
Probably if you got him in an agreement, you know, a confidentiality agreement.
Okay. All right. Last question. Are you familiar with Bill Thornton?
Somewhat.
Now, he teaches common law, and not the statutory kind. It mentions in the Constitution. But anyway, he's prevailed in certain things, but overall, I find it not to have that much effect. And I'm wondering what would be different with the special equity in that regard. You see what I'm saying? Because
we're about to find that out. You know, it's if you take that Maxi Center case and look in footnote 10 on the bottom, they give a graphical outline there of how equities had its high point in the 30s. In Florida, I think it was like about 40 cases in that 10-year period. And then every 10-year period, they give another count. And I think the last one was in the 80s. There were only 2 cases in Florida. And that there haven't been any cases. So it's like we have lost this, and now we've rediscovered it, and we're trying to figure out how it works again.
Yeah. Well, I sure hate to be a guinea pig, you know.
Yeah, I know. There's a lot of people right now that we're right in the cutting edge, and we can't really help them as much as we could because we're still discovering, you know, which direction to go. And we're going kind of slow because we're looking under every rock.
Yeah, well, you know, the pioneers are the ones that take the air.
Uh-huh.
All right, thanks a lot.
Well, I appreciate your questions. There were some good ones in there. Thanks for coming on. Anybody else have a question? Press *6 followed by 1. *6 followed by 1. Raise your hand, get in the queue line. *6 followed by 1. Anybody? Question?
Christian, can you hear me?
Yeah, who's this?
This is Hank in Florida.
All right, how you doing?
How you doing? I listen to you quite often, as much as I can, and I don't put in much input. But what do you do on the question of
you're kind of breaking up. Wait.
A private problem to a judge's chambers when someone do a UCC 1 on the case and then have it presented by a notary to the judge's chambers even before you get to court?
I understood. Right, yeah, you could do it before you got to court, yeah.
And wouldn't that take it right out of the public and put it, you know, once you get to court, wouldn't the judge would have that paper in front of him and he would know that it would be private matter and should be in chambers, right? Or camera.
And this was all before the first appearance?
I ask a question, could we take this into camera?
This was all before the first appearance?
Well, you got your case number, and you make that your claim, you UCC, and make a trust out of that, right?
Yeah, right. I'm thinking if this was the, before the first appearance, he said all this to the judge, it might...
Well, that would be...
Converted over to
what do you call it? Not the first appearance. When you go in there to try, if you're gonna push the case or the situation, the first one's just an arraignment. So, could you have that paperwork in front of him before that arraignment, and during the arraignment, couldn't he make a decision to take it into camera?
Yeah, I could. Yeah.
Would that be the right way to do it, without even having to go into court and face the DA or district attorney or whatever you want to call him, opponent?
That possibly might work. Yeah, but if it was, like I say, before the first appearance.
Before the arraignment?
Yeah, before the arraignment.
Possible?
Right. I would say before. Yeah, before the first appearance.
But that's pretty much a direct way to get it in front of the judge, as far as I understand.
Yeah, either that, or if you're in the case, traversed in, then I would do the dismissal and the transfer. And we've changed our view on the in-camera hearing thing, because before we think there was just one court, and we had to get into in-camera to get equity. But since then, that Maxi Center case has proved to us that there are two separate courts, and we're no longer shooting for, say, in-camera and chambers, because that whole equitable side, once you're in that equity case, the whole thing is equity, whether you're in camera and chambers or in the whole...
So in other words, if you bring it up and the judge has prior knowledge, he pretty much has to go with it, right?
Yeah, you're the one invoking the equity side, yeah. If it's done properly, it should...
Right there on the public side.
Yeah, it should switch from public to private.
Right away. I think that would be a good plan, a good way to get this into private on the equitable side from the public.
Could work. You know, I'm not saying either way, but that might be one way of
with the UCC claim, and then having a notary present it to the judge's chambers. Actually,
yeah. If he had it beforehand, before everything happened, then yeah, you switched it over into equity before it even started.
This sounds good to me. I don't know. I haven't done it. I won't do any of this until I get enough under me to feel comfortable with it. But
right, I wouldn't recommend anybody do it unless they knew, what they were doing, and this. We're treading new ground here, so it's never been tread for a long time.
Yeah, since the 30s.
Yep.
More or less. You said what? Back in 1980, only 2 equitable cases.
Correct.
In Florida.
Correct. Uh-huh.
Yeah, that's a lost art.
Yep.
So to speak.
Yep. And here we were in the wrong side of the courts all these years.
Yeah, and I believe it's all the media and the television and the softening the people up, the whitewash, and everybody's got the status quo going on. They're all right with it, and everybody through the generations lost it. They don't even know it exists now.
Yeah, you're right. Like deer in the headlights.
Yeah, because they don't. When they get in there, they don't know that they don't even have to be in there if they do this right. And like you said, first thing out of their mouth usually ruins them because they don't know.
Well, we're just relearning it again.
Well, thank you for your time. I really enjoy listening to everyone because most everybody's got valid points, and very interesting to hear how the different people take care of it. As far as that getting into equity side from the public with something, I think, like you said, before the arraignment, that's what I was thinking, before the arraignment, if you could, if you're that fortunate to, let's say, confess and evade so you don't go to someplace where you can't do this, I think it's the most direct way to do it. It just seems that way. And I appreciate your comments.
Okay, thanks
on that. Thank you.
Okay, thank you. Anybody else? Question? Star 6 followed by 1. Star 6 followed by 1. Anybody raise your hand?
Hello.
Hi, Marshall.
Christian, how you doing?
Okay, good. How about yourself?
I'm doing all right. Everything is going. I really don't have any questions tonight. I just wanted to get online just to talk to you.
All right.
So, what's going on, CW?
Not much.
Let me ask you a question. Where do you see NTT going for the future?
Well, I've expressed this before. It's the discovery of the road of NTT is leading us to the God-conscious mind.
Right. Heard you say that many a times.
Yeah, it's not the fact that NTT is going to give you remedy or relief. No, it's taking you back to the God-conscious mind through the maxims.
Right.
Because that is the source of all the law.
I totally agree. Totally agree, 100%.
That's what I'm excited about.
The reason why I can relate to that is because I find myself learning how to incorporate maxims and just the whole premise of NTT into like real life, beyond just cases and litigation and claims being brought against you and you having to defend your substantive rights, just in life personally, like interpersonally amongst people. Because sometimes I have like conversations with friends or just people that I know in general, and we'll be talking about something, and then here I come with something like, well, that's not equitable. You can't do that. Yeah, and people will just look at me like, what is this guy talking about? And I find myself really being able to see how it applies to our real life situations that we go through, because many of us go through a lot of things. And even me personally, I go through my personal adversities, but one thing that I can honestly say is prior to NTT and me discovering Christian Walters and everything that you bring in, that you've taught us, I used to stress certain things. And it's like I used to be very worrisome. Got to take care of my son. We got to live a certain life. I just refuse to be, like, one of my greatest fears, Christian, is to not be able to, say, provide for my little boy when it takes nothing but a little bit of money to make everything all right. And I was just always uncomfortable with that, because we have our faith, we have our beliefs, but yet and still we have to live our lives in this commercial system. So it's like I used to stress certain things and just worry about certain things, but then afterwards I start studying NTT and learning about trust and learn about the maxims and things of that nature, and the problems don't stop, but my view on the problems has thus changed, because it's like I could see the window, I could see some relief, even though I don't have it yet. I know that I am the relief. It's me. Equity is me. So it's like Lisa was just talking about your mind being freed from bondage, and like I could totally relate, and I totally agree to that, because I don't really worry about things anymore like that. Like, I still have my concerns, and every now and again things will catch up to me, but it's nowhere near like before. It's like my whole mindset has changed, and the only thing that has changed in my life, because like I said, the problems continue to come. The only things that have changed in my life is, and I had to really think about this one day, besides time, is what I've been reading and studying, and the people that I've been talking to and building with. And I really came to the conclusion that this thing has like really changed my life on an internal aspect first, because everything externally is going to happen, but it all starts from within. So it's like I just really, I can't put it in words, I can't convey it correctly. It's like I just want to tell you thank you. It's like I feel those are the best two words that I can come up with. There's many adjectives that there may be to describe what I may feel about certain things. Just thank you, because I know I'm going to be all right, because this thing has put me on a course to where I'm going to be on this course for the rest of my life. And for me, that's big, because it really gave me direction. I had direction before, but it wasn't the type of direction that I really knew and know within myself I should be going in this particular place. So when I found this, I'm like, this is it right here. This is exactly what I needed to really unlock what I felt was going wrong, because I'm able to see certain things that a lot of people don't see, because I've been reading and studying seems like forever. When I used to be in New York and going to school on the train system, I used to be on the A train every morning. I was one of the 12, 13-year-olds with his book bag on the train, New York City, reading a dictionary. And people used to look at me like, this kid is like really reading a dictionary every morning. So it's like I've always been reading and studying, and I just love it. But this is what I really, really been looking for. And like I said, thank you very much. And I just continue to want to keep learning from you and being able to turn around and convey it to other people the best I can and pay it forward, because this is like monumental. I don't know. And another reason why I'm saying this is because sometimes, like, we don't have to be Christian Walters to understand that it can get a little frustrating sometimes, where you give your all and you give everything that you have, you and your wife, and it just seems like people are not getting it. Night in, night out, you're doing it 24 hours a day, it seems like, and it may not be the response that you probably would have thought you had, but then you're a smart man and you understood that it was going to take a separate, different, special class of people to really grasp what it is that you've seen and saw before basically everybody on the globe, because you're the only one teaching NTT, period. And that right there, I don't know of, that's like Einstein, E=mc². Like, that's what you brought to the table for me, because it's like, you want to talk about relativity? This is relative to everything in our lives, period. So it's like law of relativity, if you really think about it. NTT, equivalent for me to E=mc². And I just wanted to let you know that.
Well, thanks, Marshall. I appreciate that. You know,
No problem.
what you've been speaking is like Romans, I forgot the verse. Yeah, Romans 12:2, excuse me. Wow. Where you have that transform of your mind, that whole new attitude, or that paradigm shift, to where you have discernment, and it makes life a whole lot easier. Even Paul talked in Philippians 4, where he says, I've discovered the secret of contentment even when I was in prison there, and all hell was breaking loose all around me. But yet I had an internal peace, a peace from God, because God was at peace with me.
That's exactly how I feel. Exactly just like that. Everything was exploding around. Everything, Christian. It seemed like, people's perception are different from what is bad and what is good, but in my perception in my life, everything was just falling, it seemed like. Felt like I was in prison, just like the story you just spoke.
Yeah, it just doesn't make sense until you put the equity eyes on, and through trust, and then everything becomes clear.
Right. I tell you, I see it. I see it, so I see it. Trust me. This is the thing that's keeping me going every day. This is my fuel, my rocket fuel. This is like my natural resources that is really keeping me alive, like literally. Every morning that I get up, I'm in my books. Every night before I go to sleep, I'm doing the exact same thing, and in between.
Well, every day that goes by, this hope gets bigger and bigger and bigger, because we understand it, because we keep adding knowledge to it and understanding, and we're no longer perishing for that lack of knowledge.
Absolutely.
It explains life in sanctification that you're living right now. And we are on a path of the true worship of God.
Right.
Because if we can eliminate commerce in us not doing it, that's the only way you're going to give true worship to God.
Wow. This is it, Christian.
Choose this day who you're going to follow. Jesus was in the temple there, overturning the money changers when they were doing commerce in the temple. Told them, you're defiling my Father's house. It wasn't the fact that they were doing illegal transactions. No, they were doing commerce.
Yep.
We don't need commerce. And as soon as we get to the realization that we don't have to operate commercially, that I can take care of my bills by merging titles and extinguishing the debt, rather than taking another debt or creating a debt and then putting that debt on top of that debt and think that pays something. And all we got is double debt mounting up, and that's going to hit us all in the end like a bigger millstone around everybody's neck until finally we're all going to drown. And those that can't see the NTT path, well, I'm afraid they're going down the debt of creditor path, which is really the wide gate instead of the narrow one. And there be that find it.
Well, don't get discouraged, Christian. I know it could get rough at times, but don't stop. Please don't ever stop, because like the saying goes, if you affect the life of one person, then you've done your job. Well, you really touched a lot more than one person. Like truly, like you know who is NTT to the heart and who is not. I don't have to tell you. Doesn't necessarily have to be your TAs. It could be people from just in the public call in and tune in and just contribute every single day. And I want to take time to, give knowledge to those people and credit to those people. You know who you are. Everybody who is on the chat group and contributing and keeping it pure, 100% NTT, because we had to weed them out. And it was just a good feeling when I saw people besides you and Lisa making sure we weed out all of that garbage. As soon as somebody see it, it got to a point where you guys didn't have to do it. Somebody from the group was going to say, not in here, buddy. Get that crap out of here. And just, I just want to give a big thank you, too, to everybody else that contributes to this NTT movement that we got going on, because you people are special also. You keep Christian going, because if there was nobody to listen, he would still be reading and still be studying, and him and Lisa will just be the smartest people on earth when it comes to equity and our real rights. And I don't care what you're talking about. There's nothing more important than your rights given to you by your creator. There's nothing more important than that. There's no argument that can supersede or undermine that one statement right there. It all boils down to what your rights are. Your rights are equitable. So it's like when people call in and they contribute and they ask questions, it keeps Christian going also. You guys got to understand how important that is also. It keeps him wanting to do it for us even more, because he could tell the man is doing it from his heart. Like, trust me, people, this is not scripted. I just decided to call and talk. No questions. I just wanted to talk to Christian and just talk to everybody else. We got to we wear his fuel also, because he loves to teach. He loves to make people understand the truth. He loves to make people see the light. You got to love somebody who loves to do that for you. Never saw you before, don't know you, probably don't even know your real name, because we go by Skype handles or whatever the case may be. From all over the world, people call in, tune in, and he's doing it for us. And I appreciate that, because I don't have anybody else in my life doing that. Period. Can't speak for everybody else. I could just speak for myself, and I'm glad that he was doing it. I remember one time, I'll tell you a quick story. When I first discovered NTT, because it's funny, because probably like 3 or 4 weeks prior to me discovering Christian Walters, we were like heavy on Winston Shrout at that time. Went through the whole Jack Smiths and all of these guys and all of that, stuff like that. And I learned a lot of good, applicable information from those guys too. But I had people that I knew that were just doing all kinds of debt accreditor processes, and I swear to you, like a month or so before it, I said to myself, it has to be the trust. Like, this is my hand to God. I said to myself, and I started to tell a couple of my friends, like, yo, it has to be the trust. It really has to be, because everything else really doesn't make sense to me. And like, my people, they heard me, but like kind of brushed it off. And just at that time, I remember we just got the Winston Shrout DVDs, this seminar that he did in Canada, I believe it was. And we were just so excited about that. But the whole time, I'm still studying the Winston Shrout. But in the back of my mind, I'm like, listen, it has to be the trust. I don't care what you guys are talking about. Nothing else makes sense. But I just really couldn't at that time understand the thought that was even in my head, because I said it had to be a trust because I read a lot of things about trust, but never read it with the right eyes. And I done read through so many different OID processes, A for V's, bonds, and Geithner, and just so many different things. And for that month, I never let that thought go. It got to be something with this trust thing. Has to. And then, boom. That's when I heard you on, what you call it? It was the Wednesday night show with, what's the guy? No, it was when you were with, what's the dude's name, Christian, from Desert, exactly. I heard you on a Desert Owl show, and I said, this is it right here. And that was it. You know how, like, some people have still a problem when they find out about NTT, and no matter how long they were studying debt accreditor, like, they just never get it and do that paradigm shift that you always talk about. And it's hard for a lot of people to transition, but my hand to the man upstairs. When I first heard you talk about trust for about an hour and some little bit of time after that, listening on my computer, that was it. Period. I made the shift. It was such an easy transition for me because I was already feeling that it had to been something distrust. Then I heard you, and it was automatic, like the snap of my finger. And I didn't want to hear anything else after that because I knew I found exactly what I was looking for. And the more I listened to you, every single last question that I had in debt accreditor that nobody can answer, because I'm a very critical thinker. I analyze and overanalyze things to the point where people like make fun of me in certain ways and make jokes like, you're just too analytical. Why do you have to take such a simple thing and break it down to the 16th and lowest common denominators and all of that? And I'm thinking to myself, well, if you don't substantiate that first, how can you build anything else on top of that? And I'm like, why isn't nobody else seeing this? So I always felt like a Martian in a box somewhere until this situation came, and I said, that's the 16th. That has to be the core of it all right there. It just feels too good. And like I said, the more I listened to you, the more questions that people couldn't answer for years just fell right into place. And I listened because I said to myself, I'm not going to get on this call and talk to this man and me just not know anything. So what I'm going to do is I'm going to study this stuff and listen to this guy day in and day out. And then when I feel that I got it a little bit up to speed, then I'm going to call and start asking him some questions, because believe me, I have questions. And that's how it started for me. I listened to those audios for about 3 months before I said, okay, I'm going to call this number and get on the line with this man and just talk to him and let him know that I know this is it right here. I know that you know, and I want you to know that I know. If you want to get technical, I know this is it. And I know there's a lot of other people that feel that way. Probably not the same exact story as mine, but something similar. It's all relative, like what I was talking about. NTT equals MC squared. All right, now I'm just bugging out now. But anyway, Christian, like I said, thank you, man. Thank you, everybody else. Thank you, Lisa. Everybody that's on the Skype chat, public, keep it coming, people. Keep coming with the questions. That Gibson's book, we're going to be in this book for a nice, long time.
Long time.
Long time. It has exactly what we need. And if you don't see it, take our word for it. It'll become clear sooner or later. So that's all I really wanted to get online and say, and appreciate everything. And that's about it.
Well said, Marshall.
Hey, Eric, you're online. Oh, I'm not going anywhere now.
I just want to say, well said, and I just want to add to that. If there's one thing that I've learned from the opportunity to participate in these calls back from November 7th of 2009 is the example that Christian has set for all of us on how to just be patient and be humble, and how to continue, no matter how big or how distant the goal seems, to keep focused on it and keep going after it. And this has only been since November of 2009 that I've been involved in this, and he's been involved in his studies for I don't know how many years before. I never even asked him before. How many years have you been studying this stuff, Christian?
20 some odd.
It's not so much the years, it's the amount of hours.
Right.
Well, I've heard you say 15,000 hours before, but I think it's probably got to be at least triple that just based on all the stuff you know.
I would say probably safely double that, yeah.
Wow.
And everyone, I just want to point out that here it is. This man took 30,000 hours or whatever it is, some large number of time, and he wants to do nothing but give it. Give all the summation of the things that he's learned and share, and let that be a lesson to all of us, so we can all take that lesson and learn from this and help others, just as he has. And I know he's doing it because he's humble. And he's humbled by the Spirit. I know that. But hopefully we can all learn this as well. And the other thing I want to say is that Jeff, one of the people who comes on the calls and talks quite a bit, he lost his mother on Sunday. And if everybody would please say some prayers for him during this tough time, it'll help get him through. Because I know he needs the prayers, and I know he feels like NTT is his other family. So as his other family, let's all pray for him and help him through and humble ourselves to do that. Because he needs us right now, everyone. And just all pray for ourselves and pray for NTT that this continues and that we all get the opportunity to continue being part of it. Because when we look at all the things in life, all the things that really matter, in the end, this is the one thing we're going to be able to pass on. Not only from the next generation of ourselves, but perhaps endless generations of ourselves. Because we're going to know how to do it. We're going to know how to set it up today for it to last eternally. And that's the legacy that we have the opportunity to give and that we have to learn. That's what this all means, people. A legacy. A legacy that was given to us, granted to us by the Holy Spirit for His glory so we can continue on for His glory. And if we'll all just be humble enough to let that happen, to just let it, and to believe, well, then anything becomes possible because through Him, all things are possible. Thank you, Christian. Thank you, Lisa. Thank you, Marshall, and thank you everyone for participating, and for all those that come on the calls that are concerned that where we're at is so much more advanced than you're leveling out. Just come on, discuss your issue. That's how we learned about it. That's how we got to where we are.
Yes, sir.
Don't be so shy. Don't think we're going to beat you up because you bring some entry level issue onto the call. If there's some place we can direct you for more knowledge, we will. If we can answer the question on the spot, we will. And if not, then if it's something we haven't encountered yet, well, then it'll be something that perhaps we need to learn about. But you're going to have a pretty tough time stumping Christian, I'll tell you that, everybody. But I encourage you to try. All right. That's all I really wanted to share here. Thank you for letting me come on, Lisa.
Thanks a lot, guys. Is it my birthday or what?
Well, I don't know when your birthday is, so in case we don't know, we don't say it on your birthday. There you go.
All right. Good night, everybody. I'm signing out.
Okay. Thanks, guys. Appreciate it very much.
We appreciate you.
Okay. Boy, there's some serious just sucking up going on. I'm just kidding.
Are you doing this too now? What?
Hey, no. I did want to touch base on the point that you were making in regards to where you're talking about peace. I know it's a little bit off topic, but this was the same thing. This was actually one of the prophecies that were fulfilled in the Old Testament, because they said when the Messiah comes is that there will be peace, and they didn't recognize it because the Romans were still inherent. But that's what he said in John 14:27. He says, "A peace I leave with you that the world will not know," which he was referring to was an internal peace, not an external peace. And that was something that you touched on. And also what Eric was saying was in regards to perseverance. Two verses. Romans 5, let's see, Romans 5, it says in here, it says that we should rejoice in our suffering because we know not that suffering produces perseverance, perseverance character, and character hope, and hope does not disappoint us because God has poured out his love in our hearts by the Holy Spirit to whom he has given it. And one other passage in James where we are to consider it pure joy when we face trials of many kinds because you know the testing of your faith produces perseverance. Let perseverance finish its work so that you may be mature and complete, not lacking anything. If anyone lacks wisdom, you should ask God who gives generously to all those without finding fault, and it will be given unto you. Which goes back to the one verse, knock and you'll receive, seek and you'll find. But anyway, what I also mentioned, speaking about, in regards to, before I was talking about indenture, when we go to the trustee, should we also send them a copy of the Declaration of Independence with an allonge of the cosigner, so the trustee knows that we're claiming an equitable right and that it's no longer any kind of statutory right? I don't think it would hurt myself.
If you haven't done it to the main account, yeah, you could probably do it on the other end to the individual case.
Okay, because I actually sent a copy to the trustee. I thought it would be. I don't think it would hurt anything by saying, "Hey, I'm declaring my right endowed by my Creator," and I didn't think that it would hurt anything. I mean, they might look at it funny. They're going to look at the whole thing funny, but I felt that it wouldn't do anything.
Yeah, well, these truths are self-evident, so don't need Declaration of Independence, but that's just another piece of paper that they can see. But everything should be self-evident that these rights we have them. Can't get rid of them.
Well, you made a very interesting point, of course, Christian, is in regards to the whole commerce thing, which of course does relate back to, and that's a great analogy you use in regards to Christ in the temple, which was true, which really went to desecration. The same thing what applies today, which really, that's why you should never claim a constitutional right, because if a constitutional right is given to you by a government can also take away a right, which is statutory. But when we claim an endowed right, or an unalienable right endowed by our Creator, no one can take it away. Not any state, federal, or international government or court. I mean, once God gives it, he doesn't take it back.
I mean, the outlaw side takes away your inherent rights, but really it doesn't do that. It just suppresses them and gets you to believe that you don't have those rights. Just like it says, you've been given those rights. Nobody can take them from you. You always have them. Never can get rid of them. Can't be transferring them. Period. Somebody you believe that you don't have them, suppressing them, but you always have them. You can always go back and you've always got it. Can't get rid of it.
And that's the great thing about equity. What I like is that there's no latches or time limits there. No statutes of limitations. That's a phenomenal. That is such a big stick. That's a really big stick to knowing that, hey, once I got the trustee in a breach, I can come in 10 years later and bring suit against them if I want.
Right.
What a beautiful thing. Now I go on my time. Not the court's time, not the other side's time, my time, which will help me come of age as we learn NTT. But but I agree with especially what Marshall said is how you start developing a trust eyes in every situation. As a matter of fact, everything that, I'm signing, I'm almost like hesitating every time, and I'm going like ... and then signing my name. Almost everything that I'm signing. It could be a grocery receipt, but I'm looking at everything in trust eyes, and it does give you a different perspective. And just like what it said, you have to renew your mind. It's a renewal of your mind. And I'll tell you, it took me at least 5 months to renew my mind, and I had people really busting me about it. I mean, Eric was busting me about it, because I just was not getting it. I kept floating back and kept going to that outlaw side. Kind of like in The Godfather 3. Just when I'm out, they suck me back in. But that's just, it was a bad habit because that's all you know. If that's all you know, that's all you know. And to totally renew your mind, to learn a different system, a different sequence, it's not an overnight process, but through persistency it can be achieved, and we're still learning. We're still learning. It's very new, but it's imperative that we have the knowledge that we know what we're doing, because chances are when we get into that court, we're going to have to teach the court officers a little something about equity, because they're not going to have a clue. They've had blinders on for years as well. Kind of like what Jesus was doing with the Pharisees and Sadducees. He was teaching them a new doctrine, and all they were used to was the laws of Moses, eye for an eye, tooth for a tooth, you know? And he's going, no, it's different now. That was the tutor to begin with, but I'm here now. But that's it. That's all I got. Oh, okay, I got to keep talking. CW dropped. Okay. What do we want to talk about? Hey, Bob, how's the wife? How's the kids? How about those Yankees? No, but keep, everybody out there, keep studying to the best you can. I know everybody's got to work and what have you. There's only so many hours in a day. But keep persevering, keep learning, keep listening to the tapes. Be redundant with the audios. The audios have really helped me. You just got to keep listening to them and listening to them and listening to them. I keep them on my MP3 player when I go to the gym and I'm on the treadmill or cross trainer, which, I'll sit on there and I'll listen to a show for 45 minutes.
I got something you might be able to help people get a better grip on, Darren.
What's that?
First of all, I don't know if a lot of the folks know about your long-term experience with litigation, and maybe if you were to just share a little bit about that, then I can share what I was going to share, just so people get an idea of what your experience has been.
Well, just myself from the at-law side, I mean, I never really imagined me getting involved in the at-law side, but most people really do develop a legal knowledge normally when they get bitten by that legal bug. And you know what? They got tired of saying, I don't care what my attorney says or he's done a bad job, I'm going to learn the stuff myself. And that's really sometimes how we start on that path. And regardless of that path, I mean, myself, I've been in the state courts, the appeals courts, the federal courts. Only two places I haven't argued, and that's federal appellate and the U.S. Supreme. But who knows? There's always tomorrow. But it does give you an understanding of how it operates, and then you understand how that machine does operate in there. And the key point to, I think, any court, you gotta know the rules. Where most pro ses get killed at is that they don't know the rules, and that's what always moves the court. That's what makes the court do what it needs to do. That's what makes the other side do what you want it to do. You have to know the rules. The rules are imperative. But a lot of it is trial and error. And you really, what Christian is really taught in NTT is try to understand that NOI-SOI. NOI is basically a notice of interest. It's like an allegation. Like if I say, I saw Eric stealing a candy bar at the 7-Eleven. Well, that's an allegation, okay? Now, how do I support that allegation? Well, if I got a film clip of him putting a candy bar in his jacket, then that's an SOI. That's a statement of interest. That is supported evidence. So if I make an allegation, I got to be able to support that, because if not, it holds no water and it's easily dismissed. So anything that you make it, like you have a lot of people that are always talking about, the lower courts, they're corrupt, they do this, they don't hear my rights. Chances are you made allegations and you never supported those with evidence. And it's very important. That's why we harp greatly in NTT about creating records. The key is the creating records. One great example you could use is the Abanius case from Massachusetts, which was a foreclosure case in the higher state Supreme Court, where the judges were kind of saying, educate me, and also all they cared about was, let me see the records. Let me see the records. Let me see the records. Because
hey, Darren, will you spell the name of that case you mentioned? Because that sounds like it would be a great model for people to get an idea of how to create records.
I think it's IBENZ. Benyez, I think that's the case, and if nobody has it, I actually have the video.
What year?
It was this year. Marshall has it. That's the one Marshall's watched several times.
You're talking about that one where the attorneys argued in front of the panel.
Right.
For
That was the
assignments,
Massachusetts.
for the blank
Right.
for the assignments in blank.
Right.
Yes, a very, very interesting case, and definitely all about the record. You're exactly right.
But you got to listen. You got to listen to what they're saying in there. And where I caught, a lot of the judges were saying, "Well, explain to me." They were saying, "Educate me. Explain to me this, or explain to me why this. Explain to me." They were saying, "Okay, you've made allegations, but support it now." That's what they were saying. Support your allegation. So that's why it's important that why we spend so much time on saying, let's create records. We have to create records.
And as far as beside creating the records and knowing the rules, and you recently told me you've been in the outlaw side litigating for, I think you said about 20 years now, huh?
Well, almost, not quite that long. And on different issues. As a matter of fact, there was one case that really gave me a lot of my knowledge on, and it was ongoing. But then I could really see, now coming from NTT, I'm going, now I see how they were acting. Now, there was some situations, though, where they did exceed their jurisdiction, clearly. But it was just like, there was a guy, there's a video out that was going around on some of the legal groups, where the guy was claiming trust in the courts, and he was telling the judge that there was a trustee. Well, what the judge did, the judge ordered a psych evaluation. Well, I started seeing all the different posts of people going, oh, yeah, they do this, he should have done that. No, actually, the court acted properly because he commingled his own trust, didn't realize it, and the court acted properly and even acted properly in ordering the psych eval on him because he didn't realize he commingled his trust. He breached his own trust. The court acted properly on it. That was another good example that you could see where, of course, the paramount claim that we have, he who claims trust must prove trust. So how do you do it? Records. Records. You see, the great thing about NTT, once you start understanding this and you're looking at it at trust eyes and you're seeing any transaction that has occurred with you that, hey, I formed a trust here and I didn't even know it, all right, well, I'm going to reclaim it as a trust and I'm going to go back and I'm going to name that party, Joe Whiplash or whoever, he's my trustee because he's still holding my signature on my trust read. So what I'm going to do, I'm going to have him to perform his duty as acting as trustee. I don't care if he says he's not. If he's still holding my property, then he is the trustee. That's what it says. So
the other thing I want to bring out with you, though, that I want to help everybody with is just the things that you've seen on the outlaw side and before you got involved with NTT, and then the difference is the way you look at things differently from all your experience on the outlaw side compared to the way you look at things now in terms of your depth of understanding from what they were to what they are today.
Well, the thing is, before when I go into court, I never saw trust. Never even thought of it. Now, there was mention, you got a lot of, what's the old term is PNJ, Patriot Nut Jobs. Because you have some wacky people out there that post a lot of crazy stuff that has no validity. Why? Because they've made NOIs and there's no SOIs supporting their argument. But I never saw it the way I would argue it. I would argue the standpoint from statute, from case law to prove my point. And now you also, too, in your allegations, you also have elements that you have to prove. But now that I look at it and I'm thinking, well, the equity side, it can't be this easy. And it is this easy. Now, but you got to understand why it's imperative that we have to understand NTT. Because if there has only been about 100 cases filed since 1933 in all the courts throughout the United States, what's the chances that that court that you're in has actually seen one case of equity since 1933? Chances are they never have. So that's why you're probably going to be the one who's going to be educating them on equity. And that's why your paperwork has to be imperative. Your records have to be imperative. You have to know what you're doing once you get in there. But if you do, man, you're going to be like David slaying Goliath in any matter, especially if you're claiming trust.
And one of the things you just mentioned was records. And in order to create records, which another word for records would be evidence, correct?
Right, absolutely.
Right. Another way, or a great way to understand everything we need to understand about evidence is to read our state rules about evidence. Would you agree, Darren?
Absolutely. Evidence is imperative. Rules are imperative.
So really what I'm trying to do is I'm trying to elicit some stuff out of you to help folks that are struggling with maybe any of the court cases they're dealing with, any of the things that they're trying to understand at a deeper level that they might be just at a loss to understand. And that's really what I want to get at in our conversation for them through your experience of where they can look for the foundational things. So when they're looking at a pleading, when they're dealing with answering a pleading, when they're dealing with looking at what the other side, for example, has used to support their pleading or lack thereof, where they can turn to determine what the proper steps are. And obviously we've determined that's the rules, but also I know we've mentioned many times this, the course by Dr. Graves' Jurisdictionary. And beside those two things, is there anything else that you know of that explains it in a foundational way that you can suggest for everyone?
Well, you hit on so many subjects. That would be probably a week of internet calls on every topic, but same thing. You have to look at it now. You have to look at what your argument is. I'm making NOIs, but do I have the SOIs to back it up? Same thing on the other side. They're making NOIs, and do they have the SOIs to back up their claim? If not, then you strike everything. You have to answer everything that gets filed. Anything that they submit, you have to knock it down, and you have to, the reason why. Secondly, too, you have to look, that's I think very imperative that you have to watch, is a lot of times you will get attorneys that will be filing like statements of facts when they're the only ones filing it. And the thing is, an attorney can't do that. An attorney is either an attorney or he's a witness. He cannot be both. There's numerous case laws. So anytime you see an attorney, and just give me an example. I'm in a case right now in federal court, is where the attorney, I've hit him, I've knocked him down on every single thing. Why? There hasn't been any witness with first-hand knowledge that has come forth to lay claim or have even submitted an affidavit. So everything that he lists in there, I'm knocking down right off the bat. You never let anything just ride, because if you don't knock it down, then you agree to it. It's like a silent submission to it. And he submitted a statement of facts, and right away I went after him on the fact that he has no first-hand knowledge in this case. He cannot contest that that this is a fact. Because a fact is is a thing that is supported by someone that has first-hand knowledge, or that there's conclusatory compelling evidence to substantiate that claim to make it a fact. Other than that, it's merely an allegation, and to me, he was just peeing in the wind, as far as I was concerned. So everything that he filed, I struck down. That just to give you an idea. So you have to look at your own case of how you're filing it, and typically the only way you can move a court is to move it by rule. You'll find your rules of what you want the court to do and what you're looking for. Now, also the difference between like the state and federal, you have federal rules of civil procedure, but then you also have federal rules of evidence too, that you can also list in there in conjoining with the rules of civil procedure as well. Okay? And you have to understand that the federal courts do operate a little bit differently. Now, a lot of times is what happens, you get into the federal courts, once you file a complaint, you'll get your flurries of motions, just like what Graves says. It goes back and forth. The difference between the federal court and the state court is you cannot even get to the discovery stage into federal court until the court orders a pretrial conference. Once that's done, then you get into the discovery stage about who do you want to depose, admissions, interrogatories, what you're going to ask for discovery. That does not even to happen until you get that pretrial conference, where in the state court you can normally go after that right off the bat. And but there's, like I said,
go ahead.
No, like I said, you have to understand your rules. You have to understand your rules of court. There's also your local rules. So in other words, let's say you're in federal court, you're going to be looking up your rules of civil procedure, you're going to look up your federal rules of evidence, and you're also going to look up your local rules in the court that you're in. They also have local rules. Now, normally they have to comport to the federal rules of procedure, but sometimes there's a little bit difference depending on the court that you're in. So you do have to understand that. So there is some research that you have to do, and this is done for a purpose and to really wear you down on this at-law side, where actually the equity side is so much easier once you know the process, which of course we're like virgins in the equity side right now because it's something that no one has been doing. Attorneys are not trained in it. And I think the main reason, which we still have to clarify even further, is equity number 7, is that equity can only be performed in persona, which I think if that's true, that attorneys can't be in a court of equity, it only has to be the parties named in the trust, that could be paramount. That could be a huge hammer. Huge, huge, huge.
Now it goes to ex parte, don't it?
No, ex parte is where you only have one party speaking. The other party can be present, but they just cannot talk.
Oh,
now,
so saying just the parties of the trust, that means the other party can't even be present. Is that what you're getting at?
No, the other party can be present, but what I'm saying is that he can't be represented by legal counsel.
Oh, you mean with the parties of a trust? I get what you're getting at. Okay.
Right. If he does not have firsthand knowledge of that trust, once again, firsthand knowledge, or is not a party in the trust, then he cannot talk, and then you have to strike him down.
Right. And besides, he couldn't talk for this reason as well, Darren, because attorneys are officers of the court, which is the fictional side, and they can only speak to the titles, not the real man. So for that reason alone, we can keep the attorneys barred from the proceedings in special equity.
Right, and I would just hope that we really clarify that maxim. I mean, to the point where we know for sure that we're right in our conclusion, because I think right now it's still an SOI, that whether or not attorneys can actually show up and defend another side. Because let's put it this way. Let's say we're in a foreclosure case and I'm naming John Doe, CFO of the bank, to show up, okay? But I've also included that in my indenture that in the event this does come to a hearing, he's the only one that can show up. That means that he's going to have to defend himself personally. He cannot rely on any kind of legal counsel.
Exactly.
That's huge. Because nobody is trained in that. That's why the first thing they do is, hey, just let our legal department handle it. Hence the word legal. Right,
legal meaning the debt title or the title with the liability.
Exactly. So, but I think those are two huge points that favor the equity, is that there's no statute of limitations or latches, and that equity can only be performed in persona. I see those as two huge ones, because really, if you go in there with half the knowledge and know what you're doing as far as equity, you're going to be basically teaching the whole court of what equity is.
But also going in there competent with a foundational understanding of the rules, so you can go ahead and properly traverse through the outlaw side, so you can teach the court about equity and get into the private.
Right. And
watch
we also
watch that court change right before your eyes.
Yeah, because they're gonna be on their heels. They're gonna go. The judge is gonna be looking at the bailiff, going, "You ever heard this?" And just like when anything gets filed, even to the clerk's office, the clerk is going to be going, "Have you ever seen anything like this?" They're going to be buzzing in those courthouses and those clerk of court offices. The first thing they're going to be doing is submitting it to the chief judge. I guarantee it. I guarantee.
All right, and then and I'm sure you speak of that from some personal experience of a friend of yours that is I don't know if I should say it, that you said you had to bring the evidence of some of this stuff to him. If you want
I got a personal friend that I also do some research for him. He's a retired judge in Florida, and heck of a nice guy, very fair, very honest, wants government to act properly, just the way that they are supposed to act. And I really praise the guy, but we butt heads. Now, of course, I've come up with some different conclusions where, even though he's adjudicated more than 8,000 cases, he never heard what a notarial protest was until I showed him, because at first he thought it was PNJ, Patriot Nut Job stuff, until I showed him and supported it by U.S. Supreme Court case law of the validity to it. I started talking to him about equity in two sides of the court, and he's going, "Darren, should we get you a straitjacket?" I go, well, here, let me show you the Maxi Center case. Let me show you Gilbert's law summaries on trust. And let me show you equity maxims. Now, just touching on that part, he came back to me, and I'm sure he talked to some of his cronies out there, because he's got some very sharp people that he's in contact with. He came back, he said, Darren, you're 100% right, but I've never done an equity case in my life. Wouldn't know what to do if I did.
Key word. That judge sitting on the bench during his career while he was on the bench, he wouldn't have known what to do. That's the key that I want to point out about this that you just shared, that everybody needs to know, that just as it's our duty to know the rules, it's our duty to know how to educate these judges, because if we can't educate them, our case is going to go nowhere.
Right. Exactly. And you know why it was the same, and the way that I look at it is that why it's paramount that we have to know this stuff so well is the same thing if you look at it, and I always try to relate it even to the Bible is when even Jesus began his ministry, they were saying, who is this man? But he talks with such authority. Like, hey, this guy knows what he's talking about,
Wonderful metaphor, because that'll be us.
Well, right, and and even you bring it up, there was someone was saying something about a Bruce Lee pleading. I thought it was kind of funny. But, and this is kind of like learning from CW, everything, but he has the experience, and of course we're following on his teachings, which are very fair, very honest, and on point. A lot of times he's way over our head, but that's why we got to ask stupid questions at time, and there is no such thing as a stupid question. But it was funny. If you ever read on the man himself, he was quite astute. He had a doctorate degree in the University of Washington, plus he was a cha-cha dancer of Hong Kong, and he created his own form of martial arts called Jeet Kune Do. Incredible individual, very critical, but he was also a philosopher. And he wrote a poem, he says, he who knows not and knows not he knows not, he is a fool, shun him. But he who knows not and knows he knows not, he is simple, teach him. But he who knows and knows not he knows, he is asleep, awaken him. But he who knows and knows he is wise, follow him. Wow, I'm deep.
Well, that's very interesting that you take that metaphor of somebody that's known worldwide, that some of the things we haven't known about him, and we liken that to the situation that we're currently personally involved with, and look at the opportunity of this becoming something even that affects the world far more than Bruce Lee ever did. Not that he didn't affect the world, but could potentially affect the world in a much deeper and greater way. What a great comparison. Darren, I appreciate you taking a few minutes and sharing your experience and and emphasizing all of these things about the rules and your experience with your friend, the retired judge, because I think that'll really give people a very clear mission to let them know how much they're going to have to know their craft, their ability to express trust and prove it.
One other thing I want to add is that, if anything, there's no shortcuts. There's no silver bullets. There's no filing forms, and all your problems go away. The actuality of it is that you have to study, you have to read, you have to know this stuff. It's a reap and sow process. What you put in is what you're going to get out of it. Okay? You have a lot of supportive people on this group. We all try to work together. At times we knock heads, but hey, it is like with any company or corporation, you will have a difference of opinions at different times, but we're still striding in the same goal and still moving forward. But you yourself, no one's going to know your rights except yourself. Nobody can defend your rights except yourself. So that's the big key. You got to put the time into it. You got to know this stuff.
Thank you for sharing that as well, because if people don't realize how much time that it takes to understand the rules, not only to read them, but to understand them and decipher them, and just look for a few cases or a lot of cases where they apply, and then, of course, go and spend some time in the courtroom observing what's going on so they can understand the difference of what's going on the outlaw side and look at it through the equity eyes, which I'm sure has been quite the the wonderful light that you've discovered since you've gotten involved in NTT, but also to develop some friends in the legal community so they have somebody to consult with and have some conversations with, and then bring cases to prove NTT and the notarial stuff and the things that they discover, instead of just being deciphered as another PNJ, Patriot Nut Job, because, again, we have to back up what it is that we claim. So
exactly. And that's the key point. Think about it with everything that you do. If you're making an allegation, can you support that allegation?
Right. And I just appreciate that you took the time this evening to share all those things, and that you're so open with everyone, because I'm sure that everyone is going to appreciate the experience that you've had in court, Darren. And is there anything else beyond what you've shared already that you'd like to?
I think the equity side is exciting. It's really exciting. At times, it's like anything else. You're going to be confused. Sometimes there's not going to be clarity. But you got to understand, this has kind of been finding like Solomon's mines here. There could be the treasure here, and the thing is though, we're getting to the point where it is virgin territory, but it could be the Achilles heel to everything that we're looking at to stop the wrecking machine that has happened since 1933. So all I could say is what you put in is what you're going to get out.
Thank you so much for sharing all that, Darren. If that's all you have to share, I'm probably about ready to end it, because I know CW he dropped off the call. He was cut off. So if you're good, I'm good. Are you good?
I'm good. Definitely good. I got work to do.
Thank you, Darren, for sharing. Thank you so much.
All right. Talk to you later.
All right. Good night.
Bye.
And that's it, everyone. Sorry, CW dropped off. He lost the call. And if everyone will please contributing to the Welcome NTT group, and for anybody that's new on the call, of course, please Skype Faith, then the number 2 Trust, to be included in the Welcome NTT group, and to get the links for the downloads from past shows, and all the book list, and all the books that we've talked about over the course of time, and get included in our group if you're new, because we're always discovering and learning new things, and we're excited to share it, and we'd love for you to participate and share too. So thank you, Christian and Lisa, for giving me the opportunity to talk a little bit tonight, and thank you, Darren, as well. So that's all we have to share this evening. Good night, all.